Politicians write privacy laws, and politicians pass privacy laws, so it should not be a surprise that politicians have written these laws so that they and their political parties are almost entirely unregulated. Hi, my name is David Fraser. I'm a privacy, internet, and technology lawyer with the Canadian law firm McGinnis Cooper. I also teach internet and media law at the Schulich School of Law at Dalhousie University. In this channel, I try to provide educational and informative content about Canadian privacy and technology law. You should check out the full disclaimer below, but you should know that this is a complicated area of the law, and this is a general overview. This issue came across my Twitter feed recently when Naomi Sayers, an Indigenous woman and lawyer based in Sault Ste. Marie, Ontario, tweeted about her experience looking to run as a candidate for the Ontario Liberal Party in the upcoming provincial election. In order to vet her, the party asked for the passwords to her social media accounts. They said it was to speed up the process. Not surprisingly, that raised huge red flags for her and for others. It's not the first time something like this has happened, and because political parties are largely outside the realm of privacy regulation that most businesses and public institutions need to follow, it's likely not the last time that this will happen. Since politicians write privacy laws and politicians pass privacy laws, I think this is by design. So why does this matter? In the last decade or so, people have become increasingly concerned about how their data can be used by political organizations to influence voting or non-voting behavior. We've all seen pretty gross political advertising through mass media, but the concern has been driven by the ability to profile individuals and to micro-target them with messages for political purposes. Susan Delacourt wrote an interesting book about the convergence of political messaging with modern marketing that's worth checking out. And then there were huge concerns about manipulative use of data for political advertising in the US 2016 presidential election and in the UK for Brexit. Not surprisingly, there were concerns about what could happen in Canada, particularly as our political parties bring in operatives and consultants from the US and the UK. To understand how this happened, you need to understand the mess of privacy laws in Canada and the gaps between them. And because this is Canada, there are also jurisdictional issues to consider. We have federal and provincial privacy laws. We have public sector and private sector privacy laws. The gaps in privacy laws simply exist. Every jurisdiction in Canada has public sector privacy laws, which regulate the information that government institutions, and public sector bodies like school boards can collect, use, or disclose. None of these privacy laws include political parties in their purview. The only time a politician is scooped up in these laws is when they are acting as a public servant, such as a government minister, and that's only because the privacy law covers the government ministry or department. We have private sector privacy laws in British Columbia, Alberta, Quebec, and from the federal parliament. The federal law, called the Personal Information Protection and Electronic Documents Act, regulates the collection, use, and disclosure of personal information in the course of commercial activity. Political parties are not seen as engaging in commercial activity. The Quebec law governs persons carrying on an enterprise, which does not include political parties. The Alberta law applies to organizations in that province, but it specifically says that it does not apply to political parties, constituency associations, or candidates for public office. So Alberta went right out and said it does not apply to political parties or candidates. So what about British Columbia? As I'll discuss shortly, there's a case to be made, and some are making it, that BC's Personal Information Protection Act does include political parties and associations, whether they are provincial or federal, when they operate in that province. In response to the growing concern about lack of regulation in this area, the federal government proposed and passed what I consider the absolute least it could do. The 2019 Elections Modernization Act did not bring federal parties under comprehensive regulation either through the Federal Privacy Act or PIPEDA. Instead, it simply requires political parties to have a privacy policy. That's it, the bare minimum. The legislation also imposes an obligation on online platforms to create and maintain a registry of political ads shown on their platforms in order to increase transparency. Advertisements must be included in the public registries on the first day that they are published on the online platform. The registry must be accessible via a visible link and remain accessible to the public for 2 years following the general election. The data must be maintained for 5 years following the election. The registry only contains an electronic copy of the advertisement published on their platform and the name of the individual who authorized the publication. It does not include information on how that particular ad was targeted. It's a bit of progress, but not much. And this only applies to federal parties and federal elections, not the 13 provinces and territories. In 2019, the former Information and Privacy Commissioner for Saskatchewan pressed the issue to see if federal political parties could be shoehorned into the Personal Information Protection and Electronic Documents Act. The Federal Privacy Commissioner wrote in March 2021 that the parties are not engaged in commercial activity, so that PIPEDA does not apply to them. While a judge is the final word on the interpretation of PIPEDA, it's clear that the Commissioner at least sees political parties as outside the scope of his jurisdiction. I agree that this is an accurate reading of the law, but I don't think that the exclusion of political parties is right. Meanwhile, interesting things have been happening in British Columbia. 3 British Columbia residents asked the federal Conservative, Liberal, NDP, and Green parties, all of which are registered political parties under the Federal Canada Elections Act, to know what personal information they possessed about them, how it was used, and to whom it had been disclosed. Apparently, all 4 organizations responded, which is a positive thing. In December 2019, the individuals complained to the BC Commissioner seeking an investigation under PIPA into the privacy protection practices and policies of all 4 political parties. The letter said that the political parties' responses were inadequate and did not satisfy their obligations under BC's private sector privacy law. Not surprisingly, the political parties objected that because they're subject to the rules of the Canada Elections Act and other federal statutes relating to the collection, use, and disclosure of personal information, British Columbia's PIPA does not apply to their personal information practices. They argued that they're outside of the Commissioner's jurisdiction on a range of interesting constitutional and jurisdictional grounds. Well, at least interesting to a lawyer. In a long and detailed decision written by David Lucadelis, who is the province's former commissioner, it was found that PIPA is a constitutionally valid law in respect of property and civil rights and matters of a local nature in British Columbia. He didn't agree with the arguments put forward about constitutional doctrines of paramountcy and interjurisdictional immunity. At the risk of grossly oversimplifying it, if they're subject to other BC laws of general application like highway traffic laws, they're also subject to this particular BC law. The political parties are seeking judicial review before the courts in BC to have this overturned, so we'll have to wait and see how that goes. In the meantime, unless you live in British Columbia, you have no privacy rights vis-a-vis political parties. This means that if you apply to run as a candidate, they can break all the rules and norms about background checks and candidate vetting that apply to most organizations. If you're a voter, you have very limited rights about knowing what they know about you, how they are using it, and to whom they have disclosed it. That's a serious gap that should be addressed, although I'm not holding my breath for that. I hope this has been of interest. The discussion has obviously been at a pretty high level, but hopefully provided a general overview of the lay of the land for privacy when it comes to political parties in Canada. If you have any questions or comments, please feel free to leave them below. I read them all, and I try to reply to all of them as well. If you need help in this area, please reach out. My contact information is in the notes as well. And of course, feel free to share this with anybody for whom it may be useful. Thanks for tuning in.